September 17th, 2014 was a beautiful fall day. At the morning recess, my clerk said, "Your Honor, there's this case that's come in from Hamilton. It's about a health concern involving a young girl from the Six Nations." And so began the most important case I've decided in my 20 years as a judge. The young girl from Six Nations was JJ. In August 2014, she was diagnosed with acute lymphoblastic leukemia, or ALL. The oncologist testified that with chemotherapy treatment, JJ had a 90 to 95% chance of being cured, but they were unaware of any survivor of ALL without chemotherapy treatment. Although JJ had commenced chemotherapy, it was continued later in August when JJ's mother, DH, withdrew her consent for further treatment. The chemotherapy had been very difficult on JJ, and Mom had wanted to give JJ a break. This was the second First Nations child to withdraw from chemotherapy treatment at McMaster Children's Hospital in less than a year. As a result, Hamilton Health Sciences, the umbrella corporation for McMaster Children's Hospital, brought an application under Section 40 Sub 4 of the Child and Family Services Act to have Brant Children's Aid Society apprehend JJ and return her for the resumption of chemotherapy treatment. Most judges will say, well, I'll let my judgment speak for itself. But tonight I'd like to go behind the scenes of my judgment a bit. First and foremost, the court expanded the parties to include JJ's parents and the Six Nations Band Council. The Office of the Children's Lawyer was also involved. In reviewing the material filed, I knew the ramifications of this case would be significant. I knew our country's history was all too often one of ramming decisions down the throats of First Nations communities without affording them the opportunity of making full representations. That simply had to change in my view. I relaxed the publication ban and the in-camera nature of the hearings under the Child and Family Services Act to afford the Six Nations community the opportunity to attend the court sessions, to understand how the case was playing out in my court. Having dealt with this procedural issue, I then heard 9 days of testimony and argument on whether JJ should be taken into care to resume chemotherapy treatment. Two principal issues emerged from the trial. One was whether my court was the proper forum to decide this case, or whether, as the CAS of Brand had argued, the case should be before the Consent and Capacity Board as provided under Ontario's Healthcare Consent Act. And two, what application, if any, Section 35 Sub 1 of Canada's Constitution Act of 1982 had. I rejected the argument of the Society that this case should be before the Consent and Capacity Board. Both the legal precedent and common sense, in my view, dictated this very family matter should be before me, a family court judge. The second issue revolved around the application of Section 35 Sub 1 of the Constitution Act 1982, which reads, quote, "The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed." Ladies and gentlemen, Canada's Constitution was repatriated in 1982. Well, I went to law school from 1977 to 1980. I took constitutional law in my first year, so I learned about the British North America Act. There was no Constitution Act of 1982 when I went to law school. In fact, our Constitution Act since 1982 has in large measure been shaped by its application in our criminal courts. And although the Child and Family Service Act is subject to constitutional oversight, my time as a judge probably saw me consider the Constitution no more than 5 times in child protection cases. So here I am with this incredibly important case, going back to square one in constitutional legal research. You see, our appeal courts have the luxury of law clerks and articling students, plus factums and legal briefs filed by counsel. In the Ontario Court of Justice, a trial court, my court, not so much. And so it was that at the beginning of November 2014, I found myself in the Brant County Law Library, starting with the general text, Professor Hoag's The Constitutional Law of Canada, and proceeding to the specific source, the Supreme Court of Canada's decision in Regina and Vanderpeet. I can honestly say I had no idea how I was going to decide this case. It clearly came down to where the law, as applied to the facts in this case, would take me. And so, to quote from former Chief Justice Lemaire in the Vanderpeet case, quote, where an Aboriginal community can demonstrate that a particular practice, custom, or tradition is integral to its distinctive culture today, and that this practice, custom, or tradition has continuity with practices, customs, and traditions of pre-contact times, that is, pre-European contact times, that community will have demonstrated that the practice, custom, or tradition is an Aboriginal right for the purposes of Section 35, Sub 1. Armed with this principle of law, and having accepted anthropologist Professor Don Martin Hill's evidence of the practice of traditional medicine by the Haudenosaunee, or people of the Longhouse, during pre-contact time, and then the evidence of Dr. Karen Hill, who currently practices medicine on the Six Nations, along with Alva Jameson, a traditional medicine healer, I concluded the test for affording protection under Section 35(1) of the Constitution Act had been made out. And yet this conclusion, in my opinion, needed to be further tempered to avoid abuses and to maintain constitutional integrity. To that end, I wrote the following at paragraph 80 of my decision. One of the issues raised by the court during the hearing was the issue of integrity. To this end, I would reiterate how the evidence points to DH as being deeply committed to her Longhouse beliefs and her belief that traditional medicines work. She has grown up with this belief. This is not an 11th hour epiphany employed to take her daughter out of the rigors of chemotherapy. Rather, it is a decision made by a mother on behalf of a daughter she truly loves, steeped in a practice that has been rooted in their culture from its beginnings. So having dealt with the integrity issue, I could then conclude the following, quote, it is this court's conclusion, therefore, that DH's decision to pursue traditional medicine for her daughter JJ is her Aboriginal right. Further, such a right cannot be qualified as a right only if it's proven to work by employing the Western medical paradigm. To do so would be to leave open the opportunity to perpetually erode Aboriginal rights. And so it was that on November 14th, 2014, I dismissed the Hamilton Health Sciences application to have the CAS of Brant bring JJ into care to resume chemotherapy. Stopping here, I'd like to make a couple of points. First, this case was never about the competency of McMaster's Children's Hospital, and specifically the work of the 2 treating oncologists to JJ. During the trial, I found both doctors to be incredibly competent and caring. I would not hesitate to have my own daughter cared by either of them. The second point relates to how we measure success. As indicated, McMaster's oncologists were able to quote successive treatment based on significant data tracking. The practice of traditional medicine never saw that and never sees that as a necessary component. A traditional healer simply does his or her best, and that's it. As indicated, on November 14th, 2014, I delivered my reasons in the Hamilton Health Sciences case. Under our rules of procedure, there is a 30-day appeal period. December 14th, 2014 came and went with no appeal. However, shortly thereafter, I learned an extension of time to appeal had been agreed upon. There were also whispers about an application under Section 8 of the Courts of Justice Act, which permits the Lieutenant Governor and Council, being the provincial government, to refer any matter to our Court of Appeal for its consideration. Folks, the Ontario Court of Appeal can be an unkind place for trial judges. You'll have Court of Appeal judges come to your judges' conference and say, what a great job you're doing in such a busy court. But then you'll read one of their appellate decisions where they'll essentially say, quote, clearly the learned trial judge had no appreciation of either the law or the facts in the particular case, close quote. Whatever process was going on behind the scenes, it eventually came to a head in April of 2015, when counsel for all the parties requested a meeting with me. There was no question my decision was controversial. Yet despite this, I felt that my decision had a logic to it based on the application of the law to the facts. More importantly, I simply felt it was the right decision to have made for this family. Consequently, when I went into the meeting, I took the position, listen, it's going to take a lot to change my mind. So in addition to counsel at trial, DH now had counsel, and the province of Ontario, in the form of the Ministry of the Attorney General, Crown Law Office Civil, not only had one lawyer, they had 3 lawyers. Province always comes at you in waves. Right, Speaker of the House, Levac? After initial pleasantries, I basically indicated it was not going to be easy to convince me to change my mind, to which Mother's Counsel made this impassioned plea. He spoke about the unprecedented cooperation he'd observed since the court rendered its decision, how the parties, after a lot of hard work, had come together to form a healthcare team for JJ that included a senior pediatric oncologist from Toronto's Sick Kids Hospital and a Haudenosaunee chief who was also a practitioner of traditional medicine. For the rest of that day and the better part of another day, we discussed the case. I understood the concern raised by the province about whether my decision had adequately expressed the need for the children's best interest to be paramount as a consideration in child protection cases. Time and again, we went back and forth among counsel seeking consensus. We eventually did, and later in April, the court reconvened one last time to add 2 concluding paragraphs to my decision, which originally had read as follows. Quote, in applying the foregoing reasons to the applicant's Section 40(4) application, I cannot find that JJ is a child in need of protection when her substitute decision maker has chosen to exercise her constitutionally protected right to pursue the traditional medicine over the applicant's stated course of treatment of chemotherapy. To which I added the following. But implicit in this decision is that recognition and implementation of the right to use traditional medicines must remain consistent with the principle that the best interests of the child remain paramount. The Aboriginal right to use traditional medicine must be respected and must be considered among other factors in any analysis of the best interests of the child and whether the child is in need of protection. Taking into account the Aboriginal right and the constitutional objective of reconciliation and considering carefully the facts of this case, I conclude that this child is not in need of protection. In law as well as in practice, then, the Haudenosaunee have both an Aboriginal right to use their own traditional medicines and health practices and the same right as any other people in Ontario to use medicines and health practices available to those people. This provides Haudenosaunee culture and knowledge with protection, but it also gives the people unique access to the best we both have to offer. Facing an unrelenting enemy such as cancer, we all hope for and need the very best especially for our children. For the Haudenosaunee, the two sets of rights mentioned above fulfill the aspirations of the United Nations Declaration on the Rights of Indigenous Peoples, which states in Article 24 that, quote, Indigenous peoples have the right to their traditional medicines and to maintain their health practices. Indigenous individuals also have the right to access, without any discrimination, to all social and health services, close quote. Today, we need to recognize that our collective desire to provide healthcare services to our First Nations communities can see us choose the best both traditional and mainstream medicine have to offer. And yet, to get to that goal, there may be occasions we need to work out a compromise. That's not a sign of weakness. That's the sign of the strength of a democracy. In its final analysis, the Hamilton Health Sciences case stands for the proposition that First Nations communities now have the constitutionally protected right, a right also recognized by the United Nations Declaration on the Rights of Indigenous Peoples, to choose the best both traditional and Western medicines have to offer.